For everyone in the chat, I want to welcome you to the event and want to welcome you to Waheeda's session. So we're going to be talking about key considerations and changes in employment law today. Well, Waheeda's going to be talking about that. I'm just going to be asking the questions. So Waheeda is actually the founder of Smith Employment Law, and she earned her degree in law at the University of Windsor, where she received academic awards in civil procedure and constitutional litigation. Waheeda has successfully represented both employees and employers in a variety of employment law matters, and she's appeared at various Ontario courts and tribunals, including the Ontario Superior Court of Justice, Ontario Labour Relations Board, and Small Claims Court. So if there's anything that you want to add on, Waheeda?
No, I'm pleased to be here, and I wanted to. I'll share a little bit about how the courts are doing these days too.
That's awesome. Yeah. So I'm looking forward to it. I think people in the audience are as well. So let's get started then. With the first questions that we have here. Just overall, can you tell me about any recent laws that have come into play that employers and employees should be aware of? Especially because of COVID.
Yeah. Well, I mean, in the last year in Ontario, there's been both new legislation that has come into, including amendments to the Employment Standards Act, but also actual case law decisions. And I'm actually going to focus on the one case that's really groundbreaking, that's been had employers and employees buzzing. And that's the 2020 case of Waxdale and Swegon North America, Inc. And this was a Court of Appeal decision. The employer in this case tried to appeal it further to the Supreme Court, but the application for leave was dismissed, which means that Court of Appeal case is still good law and employers countrywide are looking at it. So you're probably wondering what Waxdale is about. Well,
yeah,
it was
it's been
wrong.
It's been a huge
huge.
topic,
You've heard
actually.
about it.
Yeah,
right?
We've had, a bunch of employment lawyers speaking at our previous conferences, and they're all talking about Waxdale, but personally, I have no idea what it is. So,
Waxdale
enlighten me.
is big.
Yeah.
Waxdale is big. So Mr. Waxdale, he was a short service employee and he was terminated without cause, which means he was given a severance package, essentially. But what made it interesting is that the first element was that even though Mr. Waxdale was terminated without cause, because the termination for cause provision violated the Employment Standards Act, it made all other termination provisions void. So basically the court said you have to read these termination clauses together, even if they're in separate sections. And if one of the termination clauses is unenforceable, they're all unenforceable. And the second part that was made it interesting is that normally you've probably all seen employment contracts and they have a severability provision that says if the rest of it is illegal or a part of it is illegal, this clause saves it. It won't save a termination clause that's already void. So that was so the one line takeaway, if you want to summarize it, is that even if an employee is being dismissed on a without cause basis and the employer is not relying on the for cause clause, if that cause clause, which is a tongue twister, violates those ESA minimums, it can render that whole contract unenforceable.
Okay.
So my recommendation's been employers review and update those contracts for new employees, and also for existing employees who've been there a long time. There's some things you should think about.
Yeah, for sure. Yeah, that's great. Definitely like a huge topic. I've heard a ton of. Because I'm not an employment lawyer, I mostly have no idea what's going on. All right.
Well, that's the thing. They tried to appeal it to the Supreme Court or apply for leave, and the Supreme Court didn't want to hear it, and that means that it's right now every company in Canada and Ontario is looking at their employment contracts, especially since the decision that came out, which was last summer, and are trying to furiously update them all.
Yeah, well, that makes sense. Something to think about.
Yeah.
Okay, let's move on to the next question then. So this is a big topic as well right now. Can an employer make their employee take a COVID test, or is there anything enforceable about the COVID vaccine? Can they force the employee to take the test?
So I'll address the test and the vaccine sort of separately, even though the principles behind them are similar. So the short answer is that it can depend on the specific workplace and whether other less intrusive measures can satisfy the employer's workplace health and safety obligations and also the local public health directives. So in Ontario, for example, workers are expected to return to a safe workplace, okay? And under the Occupational Health and Safety Act, which you can see the reference to in the slide, and provincially regulated employees have to keep their workers safe from danger. And that can include something like a transmissible vaccine. So that could mean things like, PPE, sanitizing the workplace, those kind of things. But at the same time, employers have to be very cognizant of those employees' rights to privacy, including privacy about their personal health, and to make sure they're not breaching human rights legislation by, and dignity by forcing an intrusive medical test. But having said that, you'll see a case that I have in the slide. Mind you, this is a unionized one. It's retirement home.
Did you mean to have your slides up? Because they're not.
I apologize. My apologies.
No worries.
I will have it right there.
Yeah.
So this is the Can an employer make its employee take a COVID test? So in the middle of the slide, you'll see a case. And in that case, the arbitrator basically says, we could be saying that this is something like a drug and alcohol test, but it's not. And the reason being in this case, she says, COVID is novel, thus its name. Public authorities are still learning about its symptoms, and it's highly infectious. The sentence that was interesting is, in my view, when one weighs the intrusiveness of the test, a swab up your nose every 14 days, against the problem to be addressed, which is preventing the spread of COVID, the policy is a reasonable one. But what's interesting is that this is a retirement home case. It's vulnerability of the residents. That's what justified the intrusion. But so far, there has not been a court decision that answers whether mandatory COVID-19 testing would be reasonable everywhere. So for now, the takeaway is to balance the safe workplace with privacy and human rights.
Yeah. So it makes sense. Not every workplace really would need that kind of intrusive testing. Of course, for a retirement home, it would make sense.
No. And so, and similarly, the question you'd asked earlier about, can you force them to come back and take the vaccine and come back to the office? Similar. Right now, there's no governmental directive for mandatory vaccinations, and there may never be. And again, the courts have not ruled on it. And then once vaccines are, available mass, they again have to weigh those competing rights of safety with privacy and human rights legislation. And here's the thing: is pursuant to human rights, an employee can seek accommodation and refuse to be vaccinated. So on the grounds of, for example, pregnancy, if that particular vaccine can't be administered to a pregnant person, or even religious beliefs. In that case, the employer has to determine, can we meet this accommodation request? So the key at that point is for an employer to make sure to try to avoid a one-size-fits-all approach. Tailor your policy or your vaccination policy to the needs and challenges of your workplace, rather than, something like you said, a nursing home versus a retail environment.
Yeah, exactly. That makes sense.
Yeah.
So, okay. So let's see here. So Waheeda, can you tell me now, there's been a big prevalence, on LinkedIn, just everywhere, of people, using non-gender conforming pronouns and titles. Do you think that that's something that recruiters should take into consideration and perhaps update their application forms and things like that to, stay just up to date on any laws or legislations that might affect them?
Well, that's a good question, and I'm going to give a very short answer to it for now. So while it's not a mandatory requirement, updating the recruiting forms sends a positive signal that the workplace is an inclusive one. But the cautionary note that I have there is that careful about terminology, and so you better if you're gonna change something on your forms, ensure that it remains accurate. Oftentimes, when people create forms, they keep using the same forms over and over again for 20 years.
Yeah.
So if you're going to be inclusive and appreciative of that, then follow that. Also, use, if possible, examples that are like what does the Human Rights Commission say, for example, about it, or the Canadian Human Rights Commission. Government forms are a good barometer to follow. For example, Census Canada allowed for a non-binary other gender to be marked off. So follow examples there. But the other thing to bear in mind is that there's no disconnect between what's on a form and what that recruiter says or writes to the candidate during the interview process. So there should be also not just about recruiting forms, but the education behind why those recruiting forms have been modified.
Yeah, that makes sense, right? So, okay, let's see here. All right, then, the next question. So, as a result of the Black Lives Matter movement, have there been in Canada any changes in employment law or workplaces? I know it's mostly an American thing, but from your experience, have you seen any changes in Canadian legislation due to the movement?
Definitely. Well, in terms of certainly awareness, there's been increased awareness and scrutiny of workplace anti-harassment policies and discrimination policies. And as an earlier speaker mentioned about companies becoming increasingly aware that employees' words and actions have consequences, which can reflect negatively on them as an organization, especially if the employee is a high-ranking one. So last summer, I'll give you an example of what happened. The head of a payday loan company, in a letter to his employees, wrote negatively of BLM, but called it his opinion. And the letter was quite lengthy. Well, what were some issues with this? It could be viewed as discriminatory in nature because even though he was saying it's my opinion, it wasn't enough. He was sending a message on behalf of the company and not just as a private citizen. And it could have had an intimidating effect on employees. If they felt forced to leave because they were uncomfortable, they could then seek constructive dismissal damages or human rights damages. So the thing to remember with BLM and everything else is that while we have the right to freedom of expression, it's not without consequences if it's creating or is perceived to be creating an unwelcome environment for persons of color, for people who support BLM. So this man's word carried weight. It had consequences, and it could be seeing that he violated human rights legislation. And he was the CEO. So what companies are doing now, well, they're looking to create and enforce robust workplace anti-harassment policies that are in line with occupational health and safety legislation, employment standards legislation, human rights legislation. And they're proactively engaging in human rights and diversity sensitivity training, which is terrific. But as you can appreciate from that example of the CEO, the support for the equality, diversion, all of that has to come from the top down. And in this case, he resigned, and the company apologized for him.
Yeah, definitely. I totally agree that, especially in this day and age where everything is digital and everything leaves a digital footprint, you have to be really, really careful with what you say,
Exactly.
Yeah, it's very easy to say, oh, it doesn't reflect the company's beliefs, but when it's coming from the company email and it's using the company header, it's like, I don't know about that.
Yeah, and you can't just say it's my opinion and that's that be it. There's consequences.
Yeah, absolutely. All right.
Yeah. Not an unlimited right the way people think.
Yeah, well, definitely. Yeah, definitely. Okay, so next up then. So have there been any important, clauses and policies in employment agreements that you can think of now? And, when and where would you suggest to implement them?
That's a good question because most in the audience are probably familiar about employment contracts containing some standard clauses, the start date, the position, the pay, vacation, termination clause. The one thing that was not considered as often was work from home.
Mm-hmm.
But as you can imagine, as the pandemic struck and most employees started working from home, it took on serious importance.
Mm-hmm.
But there are still contracts that don't have any details about that. So what are some practical things you can include for new contracts that you're drafting, including work from home? Well, put the hours of work in there, because many people are working from home now, and that line between when work ends and when personal time begins is blurring.
Yeah.
Put the firm hour of work clauses, because otherwise you're going to have overtime pay requests.
Mm-hmm.
The place of work. Indicate where the primary place of work will be, even if it's a person's home, but put flexible language in there that lets you move employees to other locations without having complaints. And then regarding the details of your company's standards for work from home. But here's the key, is for certain things like work from home policies, human rights and accommodation, health and safety measures, safeguarding company data, all those type of things, you don't necessarily want to put those in your employment contract. You refer to their existence in your employment contract, but you put them in policies, and then you would give them to the employee when they're hired. And the idea behind it is that workplace policies are amended much more regularly than a contract, which might never change.
Right. Yeah, that makes sense. Yeah. So, yeah, go on.
Mark has a question. Says, what obligations does an employer have to do to accommodate if a female employee needs to take a lengthy leave from work to take care of kids, and does the job need to be held open like a maternity leave is a job abandonment? Well, it depends. Right now, the Ontario government has an IDEL, the Infectious Disease Emergency Leave. So it has to ideally fall into one of those categories. Now, it doesn't mean that it's a paid leave. So that's a consideration. But the person's contract also guides what kind of, like, if there's things in that contract that gives them a lot more leeway than even what the legislation offers, and that's going to obviously supersede it because they've signed off on that. But in terms of keeping the job open, there's no hard and fast rule on that. For example, if there's no option to work from home, that's different possibly. So are there other things they can do to accommodate, or do you have to be at the company or at the office or not? So it's a little more nuanced than having, unfortunately, a sort of a blanket way you can with maternity leave, which is legislated.
Yeah, that makes sense. Thanks, Waheeda. And by the way, to everyone watching us in the audience, please feel free to send your questions for Waheeda in the chat. We can take a look at them, after we've gone through all of the questions that we have now. All right. So let's move on to the next question then. So, if somebody is afraid to take transit to work, public transit, which is what I used to have to do last year, do they have a choice in coming into work, basically?
Well, I mean, that's, again, a very good question. And the reason being is, as I mentioned earlier, both under common law and under the occupational health and safety legislation, employers have a duty to make sure every precaution is taken to protect their employees. But here's the thing, is that in the past, the employer's health and safety obligations didn't extend to that worker's commute, okay? So because the employer couldn't control the conditions of how they got to and from the workplace. But here's what the employer does have control over. Does the worker need to attend the workplace? Where can, because the employer has control over where that work can be completed and when. So if there are genuine safety issues, an employee might be justified in refusing to attend work. But if they're refusing to attend work, then whether that refusal is actually justified depends on certain things. Like, first of all, it depends a lot on the public health guidelines at the time, but are they living with someone who has a pre-existing condition? Can they do the work from home? are there other alternative methods of commuting to work? Will their employer pay for it? What's the local safety transit authorities doing regarding safety? Things like that. The key here is communication between the employer and the employee. And if your employee tells you that, I have special needs and restrictions, they could be seeking, accommodation. Well, guess what? You're allowed to seek documentations to substantiate those restrictions. So, but working on a solution is important, and if all else fails, if that employee is unable to perform the essential duties of their position, even with you accommodating them, like reasonable accommodations, then they may have a right to be placed on a temporary leave of absence until it's safe to return to work.
Okay. Yeah, that makes sense. Okay. Well, let's go to our last question then. So, for the final question, since lots of people think that courts are closed right now, first of all, are they closed? And, what does that mean for employment cases that are going to trial?
So, they're not closed right now, the courts, in the sense that matters are taking place. So last spring, when the pandemic took hold, court hearings in Ontario, trials, everything got postponed. They didn't get canceled, they got postponed indefinitely. I myself had a 3-day trial that was scheduled to start in third week of April, and I have not yet heard back as to when it's going to be. But limitation periods, the deadlines, which are the deadlines by which a lawsuit has to be started, and other litigation clocks to protect people's rights, those were suspended. So it's as if the clock just stopped ticking. And then last fall, they restarted. And the courts themselves were physically closed until last year. Well, what's happening today? Excuse me. Limitation periods are no longer suspended. Courtrooms have a 10% limit if attendance is mandatory, but it really isn't. For the most part, non-jury matters are being heard virtually. Tribunal appearances, court appearances, largely remotely. Court filings are being accepted electronically. And jury trials are suspended until May 3rd. And that suspension might be extended. Part of the reason for that is jury selection. You can imagine how difficult it might be to try to put everybody in a room and go through that process.
Yeah.
The one thing that I have found interesting is that courts and judges have cautioned people to not delay matters by insisting on in-person attendance. So for interlocutory steps, things like mediations, things like discoveries where you're asked questions under oath. So judges have actually strongly encouraged the use of remote attendance for these steps to keep a lawsuit going and not delay justice for people in lawsuits. And I'm happy to say that we're finally entering an area of modernization in Ontario courts, which is a long time coming. They just got rid of mandatory faxing. I don't know how many of you have even seen a fax machine.
That is crazy to me. Yeah, obviously I'm not in law, but I think that COVID has really pushed a lot of organizations and industries, kind of force them to go digital when they've kind of been lagging behind for a long time. So, that's great for you. Congratulations.
Yeah. It's been good. It's been good that you can, just serve a document by email, by PDF, which is what most people are familiar with.
Yeah, exactly. Well, before this, I feel like it was a lot of kind of red tape, like, no, you have to do it this way because we've been doing it this way. We only accept physical. And it's like, there are many ways to secure a document online as well. It's just you have to put in a little bit of effort to do that. Yeah. But anyway, so Waheeda, thank you for answering all those questions. Again, I want to address the audience and say if you do have any questions for Waheeda regarding employment law, please do send them in the chat. We do still have a couple of minutes if you'd like those questions answered. And right now, Waheeda, you've got your contact info on screen. Is there any specific page that you want to direct people to?
Oh, well, there are resources. So if you go to Smith Employment Law, there's resources for employees and employers.
Mm-hmm.
They're split into different pages. So there's just some
Yeah.
basic topics on there.
There you go.
There's also a article, or rather a section, that deals with COVID-19 updates, and articles that have been written in the last year that I've done. And also there's a quick access benefits chart for employees and employers that I have.
Mm-hmm.
And those get updated as the government updates them. And
Okay,
as
perfect.
everyone knows, the government likes to update every time you blink. There's a new update. So
Yeah, for sure. Okay, I'm just going to type in your email into the chat here so people can easily copy and paste it if they want to. info@smithemploymentlaw.ca. There you go. So, for anyone in the chat, for recruiters in the chat, if you do need to contact an employment lawyer, I think Waheeda would be happy if you reached out to her. You can send an email to her address in the chat. And, check out the Smith Employment Law website as well. Like Waheeda said, there are updates there for employees and employers, which is good to keep on top of because of COVID-19. I totally agree that there's new changes every single day. They're going from system to system to system. It feels like with first it's gray zone, then it's green zone. I'm like, okay, I'm not even keeping up at this point. But
yeah, no, for sure. And each of those topics, questions that I was addressed, like those could have been a presentation unto themselves. Like,
absolutely.
I had a hard time deciding on which case I wanted to share, because as soon as you get into it, you could half a dozen different ones. So happy to speak to whoever, if you want to send me an email or give me a call or message me through LinkedIn, happy to connect.
Absolutely. That's great. Well, if anyone in the chat is interested in in-depth employment law topics, we do have the Employment Law Conference coming up at close to the end of the month, which you can find on our upcoming events listing, which is in the reception area. And, Waheeda, I want to thank you for, again, for presenting, for answering all those questions. You were very actionable in how you answered them, which is really great, for people who might not be in employment law specifically. So again, thank you for that, and thank you for coming out to the event and for speaking. It was a pleasure to have you here.
It was my pleasure as well. Thank you very much.
Absolutely.